All right, everyone, let's get started. Welcome. My name is Ron Vogel. I'm Executive Director of CodeX. CodeX is the Stanford Center for Legal Informatics. It's a joint center between the law school and the computer science department. Our mission is to use information technology and make the legal system more efficient for all the stakeholders in the legal system. So this talk is co-sponsored with our Center for the Legal Profession, which Professor Rhode directs. Lucy is here. She's the executive director of the center. So yeah, it's a great honor to have Professor Rhode here with us today. Professor Rhode is the Ernest McFarland Professor of Law here at the law school. As I said, she directs the Center for the Legal Profession. She's also director of the program in Law and Social Entrepreneurship at Stanford. She's one of the most accomplished scholars in legal ethics in particular. She's most cited. She's written over 250 articles and many books that are really the standard in the field. She's received so many recognitions that are really hard to count, from the ABA, the White House Prize for lifetime work in increasing access to justice. And she's also a member of the American Academy for Arts and Sciences. Professor Rhode is a graduate of Yale College as well as Yale Law School, and she's also a very prolific columnist for the National Law Journal, and also publishes editorials for the New York Times, the Washington Post, Boston Globe, and Slate, and so forth. So it's a real pleasure to have you here today. Professor Rhode will be talking about innovating within the professional monopoly, the law of unauthorized practice meets the technology boom. And so without further ado, I'll turn it over to you.
That do it for you? All right, sorry. Here I am talking about technology and unable to master the basics of how to get the mic to record. It's a great pleasure to talk about this subject. It's one that's engaged my interest for really well over 3 decades. And I'll just give you a sense of why I became interested in the subject matter, because I think it's still relevant for our conversation today. I was a law student at Yale working in a legal aid office in the family law unit, which did intake 1 morning a month. That was all the clientele they could absorb. And if you needed an uncontested divorce and you were poor in New Haven, Connecticut in the mid-1970s and you didn't show up on that morning, you didn't get a lawyer. And you didn't have any do-it-yourself services or forms. So essentially, although the procedure was very simple, 3 basic forms and a pro forma hearing before a very bored trial judge that lasted minutes, it was virtually impossible to do it by yourself. The office, realizing the enormous unmet need, decided they would prepare a kit that would enable people to fill out the forms themselves and appear pro se at the hearings. And when the local bar association found out about it, they sent him a note saying, this was unauthorized practice of law. And I, as a Yale law student, was dispatched to find out if the bar actually could sue them for unauthorized practice. And the answer, somewhat shockingly at the time, was yes. There was doctrine that said that because kits were operating in lieu of a lawyer, they were in effect practicing law. This struck me as incredibly bizarre and socially counterproductive. There was no reason why lawyers needed to be involved in the kinds of routine form preparation that most of our clients needed. And so I set about spending my years at law school doing an empirical project designed to show that. And basically the project looked at, had the benefit of a comparison group. The legal aid office decided they didn't want to tangle with the local bar, so they didn't do anything. But the local women's center basically told the Bar Association, fine, sue us, you can take the coffee pot. We're going to put out a kit. They did, and the bar decided not to tangle with them. They didn't really have a distribution system, so they weren't much of an economic threat. And so we had a control group, 100 people who had done divorces by themselves, and then 100 lawyer-prepared divorces. And we compared their files and found out that about the same error rate occurred with the pro se plaintiffs as with the lawyers, and nothing much turned on it. The clerk just returned the forms when they were inaccurate. And the vast majority of people, I also interviewed 100 people who had lawyer-assisted divorces, said they didn't get things like tax assistance from their lawyer. Most of the people didn't have a substantial amount of property in any event. The result of this was a long tome in the Yale Law Journal, which basically said the bar ought to allow lay assistance in this area. And I've been essentially rewriting that article periodically for the last 3 decades. We have been literally keeping people in unhappy marriages for a very long period of time because of barriers to do-it-yourself services. And obviously now with technology, it becomes harder and harder for the bar to really enforce its monopoly over form preparation. That hasn't stopped them from trying, however, so I thought I would share for a few minutes some of the definitions and history of bar enforcement practices in this area, and then throw it open for questions for all of you. And my thanks to Lucy Rica, who assisted me with this wonderful PowerPoint, which is telling you basically some core facts about unauthorized practice doctrine. First of all, what is it? The Model Code of Professional Conduct for Lawyers avoids definitional difficulties by avoiding definition. It says it's whatever the law says it is, and then goes on to say whatever the definition, limiting the practice of law to members of the bar, protects the public against rendition of legal services by unqualified persons. And my question for that is, how well does it protect them and at what cost? The case law isn't a lot more illuminating on the subject. So you find definitions that are literally unauthorized practice of law is the practice of law by non-lawyers, essentially a circular definition, or the practice of law is what lawyers do. How helpful is that? Or legal advice, legal representation, and preparation of legal instruments, which encompasses a large amount of technology-assisted services. The underlying theme of these cases is that the doctrine serves to protect the public. That's the theory. The reality I want to suggest to you is that it does more to protect the profession, and that we need to radically rethink the contours of unauthorized practice. Who enforces it? Well, a variety of folks. State courts have asserted the inherent and exclusive power to regulate the practice of law. They've delegated to the bar associations a large part of that authority, In most jurisdictions, unauthorized practice of law is a criminal offense, a misdemeanor, or a felony, and the bar can seek civil injunctions to enforce prohibitions. There are also standard consumer law prohibitions on fraudulent practices that also apply to some non-lawyers who hold themselves out as lawyers or who engage in other forms of fraud. More about that in a minute. Who is the target of enforcement? Mainly, it's paralegal services and document completion and assistance services. You see some lawyers who are holding themselves out as lawyers in jurisdictions where they aren't licensed. I'm not going to be talking about that today, although that's a subject in and of itself as problematic. Because we live in a world in which the practice of law is increasingly national and international and crosses jurisdictional boundaries, the state-based system of admitting lawyers is increasingly anachronistic and needs to be fixed. But my focus today, because it's on technology, is on the services that are provided through technological means and lay persons. And those are the ones that the bar sees as the greatest economic threat. This past summer, Lucy and I did an empirical project to look at how unauthorized practice prohibitions are being enforced by the bar. And we reviewed both some 100 cases spanning the last 10 years of reported decisions, as well as attempted to contact enforcement agents in all of the 50 states. What did we find as the enforcement focus? This chart pretty much sets out what they were. General civil litigation, trusts in the states, family law, housing, mortgage, arbitration, real estate, bankruptcy, debt collection, criminal. Immigration, I want to flag, because that accounted for only 3% of the reported cases. But when we asked enforcement agents if they had encountered any incidents of public injury over the last year, almost all of them who responded yes said it was immigration. So the real consumer injuries are not the ones that are the focus of bar and prosecutorial unauthorized practice prohibitions. I should note that fewer than a quarter of the cases that we reviewed had evidence of public injury. And most of the, over 2/3 of the enforcement authorities that we interviewed couldn't recall an instance of serious public harm caused by unauthorized practice in the last year. What are the particular activities that are subject to enforcement, even when they don't involve public harm? Filing papers in court, completion of documents, giving advice, in-court appearances, agency appearances, and real estate work. In some states, real estate closings are reserved to lawyers. In other states, real estate brokers can do it. There's no evidence that brokers are less effective than lawyers, but the bar has been successful politically in shutting them down in about half of states. The critical question I want to suggest is whether enforcement of UPL laws actually protects the public. The caption here reads, "I was a victim of drive-by legal advice." And the question is how many folks are getting really incompetent services. And that's hard to know. As I mentioned earlier, 2/3 of those we talked to who were enforcing the prohibitions couldn't recall an instance of significant public harm in the last year. And 3/4 of jurisdictions reported that fewer than half of the complaints that they proceeded upon came from injured consumers or clients. So despite the bar's rhetoric about protection of the public, it does not appear that that's necessarily a focus of the bar's traditional concerns. Other research similarly casts doubt on the frequency of client injury outside the context of immigration. In other nations that permit non-lawyers to provide legal advice and assist with routine documents, the studies available don't indicate that their performance has been inadequate. In one study comparing outcomes for low-income clients in the United Kingdom on a variety of matters such as welfare benefits, housing, and employment, non-lawyers generally outperformed lawyers in terms of concrete results and client satisfaction. After reviewing their own study as well as other empirical studies, the authors concluded that it was specialization, not professional status, which appears to be the best predictor of quality. In Ontario, which allows licensed paralegals to represent individuals in minor court cases and other administrative tribunal proceedings, a 5-year review reported solid levels of public satisfaction with the services provided. A study that was done in this country of lay specialists who provided legal representation in bankruptcy and administrative agency hearings found that they generally performed as well or better than attorneys, and that extensive training was less critical than daily experience for effective advocacy. I often point out that I'm a licensed practitioner in 2 jurisdictions, and if you would trust me with routine form preparation in a standard divorce case or real estate closing, you know, you would be very much disappointed, I think, with the results. So the reality is there's a real and significant need for non-lawyer services, and the public sees unauthorized practice laws as self-protective. In fact, a number of those involved in enforcing these prohibitions acknowledge the public skepticism of their effort. As one put it, nobody wants to see somebody taken in a scam, but the public doesn't want lawyers out there policing their own turf. And a lot of members of the public see lawyers as trying to benefit financially from their own problems, and that a company such as LegalZoom would help them more than a lawyer could and be less expensive. Technology has moved into the space that's been created by excessive demand on lawyer services. These are just a few of the companies that are involved in providing services, basic form completion services. The market leader is LegalZoom, which provides online document assembly of legal documents and provides access to attorneys if you need it. They claimed in their public prospectus to have served over 2 million customers, and there haven't been a lot of consumer complaints. The response by the organized bar to the rise in technology is pretty much like this. And not only do they hope it will go away, most of them think that unauthorized practice prohibitions should be more vigorously enforced. There have been a couple of actions directed at LegalZoom in particular. One, the Janssen litigation in Missouri involved a consumer class action alleging unauthorized practice. There was no evidence of customer harm in that case, but the court held that because legal technology took the legal decision-making out of the consumer's hands and actually provided the form completion, it was unauthorized practice of law. It went on to say that it was the fact that the documents were reviewed for completeness, consistency, and formatting that made the provision of this form of service equivalent to a lawyer in Missouri asking the client a series of questions and filling out the forms. So, so that was one case. There's another case that is pending now in the North Carolina bar. In 2008, they sent LegalZoom a cease and desist letter, which essentially said that because the software was selecting the terms and clauses within a legal document and which templates to use, it was the provision of unauthorized practice of law, that essentially the company had exercised legal judgment even though it was part of an automated software design system. The bar didn't get a court order to back up the cease and desist letter, and so LegalZoom filed an action claiming that its activities were protected. And the bar then filed a motion to dismiss, claiming that LegalZoom services were unauthorized practice of law. And in March this past year, the court essentially punted. It denied the motion to dismiss. It said it needed more information about the technology and whether LegalZoom software effectively made choices for the consumer. So where does that leave us? It's in a state of some ambiguity for legal technology companies. And I think the bar's response to all of this is really unwarranted. Basically, we need more protection of consumers and less protection of the profession against lay competition. And facilitating consumer choice and enhancing access to justice ought to be key concerns. There was no evidence in either Janssen or the North Carolina case that LegalZoom's services were unethical or unqualified or causing harm. And there's no reason to assume that the software that you see by this company and others is inherently problematic. What I do think we need to see is more effort by the organized bar, not to shut down these services, but to increase access to justice and to develop licensing schemes for non-lawyers to provide assistance in this area. Almost all of the scholarly experts and commissions that have studied the issue have recommended increased opportunities for non-lawyer and technological assistance. And until recently, almost all judges and bar associations have ignored those recommendations. There are a few signs of change. Partly, the ready access to online documents has fed desires for self-representation and for low-cost assistance in routine matters. The bar in Washington is allowing a licensing program for paralegals for certain specialties. In New York, there are court navigators for certain routine landlord tenant matters, and New York is considering these pilot programs as a first step towards potentially enhancing access to non-lawyer services. California is contemplating similar proposals. And I think what the ideal result would be is some sort of structure that provides protection in areas like immigration, where now people are prey to both pervasive fraud and pervasive unmet needs. Individuals often will hold themselves out as notaries and immigration consultants, and they prey on the ignorance of undocumented consumers who can't afford attorneys and who are reluctant to approach enforcement authorities if they're defrauded. And a lot of these consultants are capitalizing on the status of notario publicos in some Latin American countries where legal professionals with that title enjoy some formal legal training and have the authority to provide assistance. So, so we need to do better to protect these vulnerable consumers. And a number of countries have set up licensing structures, Australia, Canada, and the UK, which allow for nice licensed non-lawyer experts to provide immigration-related assistance. So I think we need that kind of accreditation and oversight system in this country, and in order to expand access to justice for a population that's in great need of assistance and now currently isn't being served by reputable practitioners, and probably needs a lot more assistance than standard technology can provide, given the language barriers and the technological competence issues for many immigrants. Similar regulatory systems could be developed in other contexts to allow personalized assistance on routine matters, and you could have various consumer protections regarding qualifications, disclaimers, malpractice liability, insurance, whatever, to ensure that people weren't being taken advantage of. What I think we don't want is the current system, which leaves a lot of technology providers in a state of legal ambiguity and gives the bar way too much authority to police the boundaries of its own monopoly. And over a quarter century ago, the report of an ABA Commission on Professionalism concluded it can no longer be claimed that lawyers have the exclusive possession of esoteric knowledge required and are therefore the only ones able to advise clients on any matter concerning the law. I think it's time for the bar to act on that assertion and reform unauthorized practice law and enforcement accordingly. So I'll stop there and open it up to questions.
Thank you for your talk, and thank you for speaking out on this for as long as you have. I think you're one of the very few lawyers or professors who has, and I really appreciate that. I have two questions. The first is, for any startup that's looking to get into this space, does just having a lawyer involved in your startup, do you think, provide any form of protection from UPL? And the second question is, if you take your comments to the extreme, and I'm not saying that you actually said this, the bar is a sham because the services provided by non-lawyers are, as you said, at least as good as or better in a lot of cases. So do you think that there's some risk for the bar in the long term of technology just making it completely obsolete?
I do think, to answer your second question first, that the bar is really digging itself into a hole in this area. And technology is going to be what brings unauthorized practice doctrine really into the fore. As long as it's small, low-cost form assistance services, the bar can shut those down. They don't have any political leverage. But once you start talking about big technology companies like LegalZoom, they can afford to fight back, and they will. And they're operating now in all sorts of jurisdictions where probably the legal doctrine suggests that they're in violation of unauthorized practice statutes, and the bar just doesn't want to take them on and get an adverse ruling. As to the first question, it doesn't really help to have a lawyer involved in the startup. The question will really be whether it's legal advice and assistance in form preparation, if that's what the company is doing. And that doesn't depend on whether a lawyer has approved of the forms, for example.
Deborah, is there any line to be? Oh,
yeah. Did you have a follow-up?
Okay.
Yes, thank you. And that is, would it make a difference if instead of just being a part of the startup, that the product owner, the actual designer of the system, is an attorney? And taking it to a hypothetical extreme, if the system exactly replicated the thought process of an attorney, of a licensed attorney, would that still be the unlicensed practice of law if the system reflected that?
But see, you don't have the lawyer being involved in providing the assistance to the given client. So I think you're still running into the traditional unauthorized practice of law problem if you accept the definition that the Missouri court did in the LegalZoom case. You know, I don't think that's the definition we ought to be operating with. But I don't think it matters that you have lawyers designing the original forms under traditional doctrine. That's not going to insulate companies from legal challenge.
So,
well, you know, the owner of the company is what's putting the computer in the, you know, services in the hands of the consumer. So, you know, I don't think you can't sue the computer.
But then the owner is a lawyer.
The lawyer is assisting the unauthorized practice. Lawyers can assist the unauthorized practice of law.
Right.
You know, if a lawyer owns a company in which non-lawyers are giving advice, it doesn't insulate the company from unauthorized practice of law because the owner is a lawyer. The lawyer is assisting the unauthorized practice of law.
Deborah, so you see, it sounds to me like you see change coming first sort of in the realm of enabling paralegal non-lawyers, human non-lawyers, to provide in certain areas, provide legal advice, rather than, you know, sort of getting the bar to be okay with the computer, you know, decision help.
Yeah, well, I think you're going to see change on two levels. I mean, one is courts are really unhappy with the escalation of pro se representation. And in so-called poor people's courts, represented litigants are the rule rather than the exception. And there's a lot of unhappiness because they make mistakes and they slow the court processes down. And so courts are looking for ways to assist those unrepresented litigants. And some of that help can come through technology, but mostly it needs to come through non-lawyers. And a lot of courts have set up pro se assistance centers which have non-lawyers providing legal services under the jurisdiction of the court. Whether they're engaged in unauthorized practice, in theory they aren't providing advice, they're just providing information. But the line between those two is really blurry. So you see the concerns coming from the courts, and these licensing programs they've set up are designed to deal with the pro se litigant problem. Then you see on a second front the challenges coming from the technology companies that are trying to bypass human intervention entirely and give people the tools to do it themselves without access to a non-lawyer or a lawyer.
Where would you put novel publications and law redundancy?
Well, that's their protected speech. You know, just the forms themselves. The doctrine that once said those were operating in lieu of a lawyer, that's bitten the dust. So you can publish form books as long as you're not providing individualized legal advice.
We're advising how to fill a form out.
Yeah, but it's not individualized. The key under current unauthorized practice doctrine is that it's tailored to a particular client. You have some questions
back there.
in the back, Ron?
I just wanted to follow up on the point that Professor Rhode had just raised. At the design school, we're trying to find where this opening is going to be, where we can help create this new type of navigator, especially for pro se litigants. And we've had the most luck with self-help centers in California. they are ready for technology. They come to us and say, what we do right now is not working, it's not efficient, our clients are unsatisfied, even the ones that we can see. So I think there is about to be this technology break inside of these self-help centers, especially around family law, immigration, guardianship, these kind of poor people issues where people are going to court by themselves right now. So we're talking with several legal services groups and self-help centers about doing pilots, tech-based navigator pilots. So I think some interesting stuff is going to happen in California in the next few years.
From your lips to God's ears, and I think that's the kind of innovation we desperately need in courts across the country. So I applaud you doing that, and hope you don't run into any problems with the Bar Association. But if it happens under court auspices, it's much less likely. And as I say, a lot of pro se centers now are operating in that sort of space between providing information and advice. And I think the courts are fine with that. And the bar isn't going to try to challenge anything under court approval.
I want to revisit just a little bit about the role of the document automation stuff. At some point I blogged about this. If you can show that what the lawyer would do by following a decision tree is exactly replicated in what the software is doing, and there is no difference in the outcome, it's difficult to see that as unauthorized practice. It's simply separating running through the decision tree from the interface with the client, which is efficient. So in that case, I argue if you're doing yes and no questions with definitive answers, you're fine. But where you start trying to do natural language processing, you're guessing what they mean, and that's where you're probably going to start running into more problems.
Mm-hmm. Yeah, well, I don't know whether that's going to be the direction that unauthorized practice doctrine goes, but it would make more sense than what we've now got.
Hi. I have some ideas about some projects that are at a higher level beyond the automation and such, and I wonder if you have any recommendations for potential advisors, and also I wonder if anyone's interested in forming some alliances.
Legal advisors?
As a business, as legal also, as a matter of navigating regulations, it would be a new venture that I've thought about for years, and I'm getting some good evidence now.
Yeah, well, more power to you. I don't know of anyone who might be willing to be involved, but if other members of the audience do, you've now identified yourself, find him after the session.
So I had the impression that there was a good deal of variation among the states in the zeal with which the bar is permitted to enforce the unauthorized practice stuff. Did you find that? And in particular, what would you say about California as compared to other states?
You're right that there's a tremendous amount of variation in the states, and we couldn't figure out a reason why some states seem to be. I mean, there were some states where the reason was obvious. Florida, for example, has a long history of very active unauthorized practice prohibitions, in part because they're worried about retired lawyers coming to Florida to practice. But otherwise, we didn't find any good evidence for why some jurisdictions seem to be much more active than others. California is fairly active, but it's also fairly consumer-oriented in its approach. So it's mainly concerned about immigration and fraudulent practices. So I would put it in the sort of mildly progressive category as jurisdictions go. Lucy, do you want to add anything to that? You talk to these people as well.
Yeah, I think
Is that right? Yeah. And actually in one of your prior studies, I remember one of your points was that nearly all the complaints that initiate enforcement come from lawyers whose lunch is being eaten, not from clients who are harmed by the unauthorized practitioners. Is that still the case with your new research?
You know, in the old research, it was like 2% of complaints came from injured consumers. Now it's less than half. So I would say that enforcement has moved in the right direction on that. But in some jurisdictions, you still have most of the complaints coming from lawyers. And a few jurisdictions, and you know, there's mixed evidence for how well it works, have delegated the issue to consumer fraud agencies and prosecutors, so city attorneys, state attorney generals. They really don't have the resources to pursue it unless it's a case of real fraud and serious consumer injury. So it's not an ideal enforcement structure because there's a lot of low-level misconduct that probably escapes prosecution in those jurisdictions. But the alternative, having the bar just try to shut down anything that's an economic threat, is much worse. So I'd be all for decentralizing it and putting enforcement into the hands of more disinterested authorities. If you could slightly increase the resources available to those authorities to make sure it doesn't fall through the cracks.
Are there any parallels or any lessons that can be learned from what happened through automation in the tax preparation space for the legal space?
Well, you know, it's always been interesting. Historically, lawyers and accountants came up with a truce, and basically, which says that tax advice is not legal advice. So it's been a lot easier to get automation in the tax field because already the bar has lost its monopoly there.
Hi, thank you very much for your talk. I'm interested in whether there were any enforcement actions in the early days of sites like evo.com where the legal advice is being communicated by lawyers but just through an online medium.
No, there's some questions about virtual lawyering and whether they're licensed in that jurisdiction or not. But by and large, lawyers have gotten away with that.
Going back to the consumer protection purpose of the UPL statutes, in theory, if that were truly a concern of the bar, they would disclose disciplinary information about their own members in bulk format, which to my knowledge, 0 of them do right now. They'd also disclose information about sanctions of lawyers, and you know, those happen in federal and state courts all the time, and they don't disclose that either. So is there any movement to make that side more apparent, or is that kind of falling on deaf ears?
You know, many of us have argued for a centralized database. I mean, you can now get access to that information about doctors who have been subject to disciplinary actions. You can't. There's no centralized authority. And most states don't have any online database where you can contact the bar. In some jurisdictions, you don't get any information unless probable cause or actual findings have been made. So lawyers with a lot of complaints racked up against them are, you know, still have a clean bill of health as far as consumers know when they're being hired. So, you know, the discipline system is its own mess. And, you know, we could spend another hour talking about ways to try to make that process more transparent and accountable. But you're right in suggesting that there's an irony in the bar's claims to public protection when it doesn't do very well on the disciplinary side.
that could be an interesting joint project for the Center for the Legal Profession and CodeX, building that database. So, here's another question.
I just wanted to follow with your point about the new forms of certification that you've recommended. I just wondered if any of the jurisdictions have responded to that. It makes sense, of course, you mentioned immigration, to have perhaps specialist advocates that maybe aren't licensed to practice anywhere out of that specialty. I'm just wondering if any of the jurisdictions have responded with that yet.
Well, as I mentioned, Washington has come up with a limited licensing structure for paralegals, and New York has done it for in pilot programs for a couple of courts in specialized areas. So I think there's more interest in doing it.
Actually, I don't think I need that.
You don't want to be on tape.
Family members and neighbors. Is the emphasis within the bar trying to protect itself, or is the bar really interested? Because I believe the bar is the sticking point. Is there any movement within the bar to make legal advice available to people of lesser, lower, or no means, on a basis of which is accessible?
Yeah, well, I think it's important to recognize that the bar isn't a monolithic entity. And for large firm attorneys, for example, they've got no economic stake in protecting the monopoly from at the level of routine form preparation assistance. So they're generally fine with it. It's the rank and file of the bar in many states that feel very threatened by technology and by non-lawyer competition. Also, the enforcement authorities vary in terms of how consumer-oriented they are. I think a lot of them genuinely believe that they're protecting the public, and they see that as their mission. And even though they don't require harm as a predicate for bringing enforcement actions, they've managed to convince themselves that that's what the goal is. So I'm not really impugning the good intentions of a lot of those involved in this effort, but I do think that they suffer from tunnel vision. And, if money were no object, sure, in a lot of cases, you'd be happy to have lawyers involved in these matters, but it just makes no economic sense. And when technology is every bit as good at providing basic assistance, it really is becoming increasingly anachronistic for the bar to invoke traditional doctrine.
And then secondly, people don't know who to call. And third, many lawyers aren't very articulate. Maybe that's why they're successful lawyers. Now there's a solution. The legal service company is called Costco. Legal services called Legal Shield. And it's a membership monthly, and they deliver a law firm in 49 states and 4 provinces of Canada. Any legal issue, less than $20 a month, enroll and cover the family. So that's a solution, because obviously people in criminal problems, they're public defender or court lawyer.
If they're indigent, yeah.
But that's one solution. Well, it's a little off topic because they're actually the proper kinds.
Yeah. Well, a lot of countries operate with much more robust systems of prepaid legal insurance. It's never taken off in this country, in part because we don't have as organized a union sector anymore, and it hasn't been a subject of bargaining by public servants.
Watch your advertising. This is a national brand now.
Yeah, yeah. Well, could be the wave of the future. Good.
Any final question?
Sorry, this might not be final inducing. It might just open new cans. But what about being here at Stanford? What about someone saying, why should we care if the legal profession shrinks? We're still at the top. We're among those at the top. We'll still have opportunities. What would be the response to that?
Well, I actually think the legal profession should shrink. That we're overproducing lawyers for the number of entry-level jobs available, and there are a lot of unemployed lawyers out there right now, and who are too expensive to reach this portion of the public that we're talking about. So I think the system of legal education and accreditation is broken as well, and that, as you correctly note, is not a final inducing closure for this particular lecture. It's a whole subject in and of itself. Places like Stanford will be the last to feel the effects of the market, and consequently, we're not changing our practices, but other law schools certainly will feel it and should change their practices. And the ABA accreditation structure should adjust itself to provide more access to cheaper forms of legal education.
So Deborah, in that connection, what do you think about some of the fancy big law Silicon Valley firms like Cooley or Wilson Sonsini actually starting to use some kind of form automation to service the public? Cooley apparently made a privacy policy generator tool available on its website, and Wilson Sonsini has, I think, for Series C to Series A funding, certain automation software. Well, what do you think about that in this connection?
I just don't know enough to have an opinion about it, but I'm all for innovation. All
right, well, so if there are no more questions on that note, that's a good note to end. We're all for innovation. Well, thank you so much. Please join me in thanking our speaker. All right, thank you all for coming. Our next event will actually feature Professor Bart Verhey. He'll be our next speaker in our CodeX speaker series. Do you want to give a quick plug for your next talk?
On May 8th, I will speak about forensic science applications of artificial intelligence, focusing on the normativity of good conclusions in crime cases. It starts with Lucia de Burg, a Dutch case about a nurse who has been in jail for 6 years, but now we don't believe that there were murders. And the issue has been there that statistical reasoning is very hard to apply in a legal setting, in a crime case, because on the one hand you have lawyers and lay people who have to interpret the statistical evidence, and on the other hand you have the experts, the scientists who present all these numbers, and then disaster can strike. I will try to defend that it can be done better on May 8th.
Thank you.